What we talked about last time were some of the basics of the human rights system in BC, and a little bit about what our human rights law, which here in BC is called a human rights code, the human rights code, what it protects, how it works, and what you might do if you felt you'd experienced a violation of the human rights code, which might be discrimination under the code. And so we're going to pick up on that discussion and continue to provide information about the human rights code and human rights complaints and discrimination and what you might do if you believe that you're experiencing something that might run afoul of the human rights code. So we talked last time mainly about the left side of this slide. We talked about what a complainant, a person who makes a complaint under the Human Rights Code, what they would have to show or prove to the Human Rights Tribunal to prove their case of discrimination. And if you remember, the Human Rights Tribunal is like the court that people make their human rights complaints to, and like a court, it hears evidence and decides what the outcome of a discrimination case should be. And so you can see on the left side of the slide the things that a complainant would have to show in order to prove discrimination. They would have to show, first of all, that they have a characteristic that's protected by the Human Rights Code. Who remembers some of the protected characteristics under the code? Do you remember the list that we showed you that had a number of these grounds, these characteristics about ourselves that are protected from discrimination? Who can shout out one? Age, perfect. Age is protected from discrimination. Employers, landlords, service providers are not allowed to discriminate against us, treat us differently, treat us badly on the basis of our age. Remember any more?
Ethnicity.
Sorry?
Ethnicity.
Our ethnicity. So there's 4 on the list that relate to our ethnicity: our race, our ancestry, our place of origin, and our color. I almost forgot the 4th one. So those sort of combine and overlap to make up our ethnic identity. Great. Any more?
Sexual orientation.
Our sexual orientation can't be discriminated against on the basis that we're gay, straight, bisexual, neither, somewhere in between.
Gender.
Our gender, great. Our sex, whether we're male or female, or again, non-binary, somewhere in between, neither. And related to that, our gender identity and gender expression, our felt sense of our gender and the way that we express our gender out in the world. These are protected from discrimination. Great. Any more? Income. Interesting. In fact, income is not one of the protected characteristics, although there's a lot of people that think it should be. And other provinces in Canada do have not exactly income, but what's referred to in most places as social condition is protected from discrimination in a couple of different provinces' human rights legislations, but not in BC. And a lot of people think that's a big problem because discrimination against people who are poor is pretty common, unfortunately, and does happen. And it means that people who do face discrimination on the basis of poverty or low income may not have an easy remedy through human rights. Yeah.
Which is the
Here's
one
one.
for like rent.
Tennessee, yeah. There's one area in the Human Rights Code where source of income
Source of income, yeah.
is protected, and that
Totally.
is Tennessee, which I never deal with. So
Yeah.
really, I had the slide from last time, so I was like, that sounds kind of familiar.
It doesn't come up too much, that's right. So like amount of income or low income or fact of not having an income, not protected.
Yeah.
Source of income, and thank you for the clarification and opportunity to expand on that, is protected in the tenancy context. So a landlord is not allowed to refuse to rent to someone because they are on a pension or on disability or other forms of social assistance, for example. So that is protected. Any other protected characteristics that folks remember?
Religion.
Religion is one. Can't be discriminated against on the basis that you are a particular religion or that you have no religion. Any more?
Disabilities.
Yeah, disability. Disability is protected under the Human Rights Code. Employers and landlords and service providers can't discriminate against us on the basis of both physical disabilities and mental disabilities. And if you remember, we had a bit of a conversation about like what is a disability under the Human Rights Code, and there's no list that we can sort of look to and say, okay, yeah, that one's in, that one's not in. But the Human Rights Tribunal has given us some guidance about what will be considered a disability. Does anyone remember what some of the critical requirements are for something to be considered a disability under human rights legislation? What do you have to be able to show?
Has to be permanent.
It has to be at least, even if it's not quite permanent, has some degree of like persistence. So a temporary thing like catching a cold, getting sick like that, where you're gonna get better pretty quickly, doesn't have that degree of permanence or persistence. Yeah, that's a key piece. That's the first thing that a complainant has to show, that they have one of these protected characteristics. They have a disability, or whatever the characteristic might be that's at issue. And for these workshops, we're really focusing on disability-related complaints. So the second thing that a complainant would have to show to make their case of discrimination is that they experience negative treatment or some kind of negative impact. Something bad happened to them, treated badly by their employer, lost their job, didn't get hired. There's sort of no end to the potential things that might constitute the negative treatment or the negative impact. And then the last thing that a complainant has to show, and this tends to be the trickiest thing to show. In my experience, number one and number two are generally not that much of an issue. There's not really much argument about whether number one and number two are met, but number three is generally the hard part for complainants. They have to show that their protected characteristic was connected to the negative thing that happened to them. They have to show that their disability or their sexual orientation or their religion or whatever it is was part of the reason for the bad thing that happened. It was connected to that negative impact in some way. Because what the tribunal says is that it's not enough to just have a protected characteristic and suffer a negative impact. You have to be able to show that they're related, that the protected characteristic was a factor in why the negative thing happened. So that's the complainant's case. And what we're going to spend most of the rest of today talking about is the other side of the equation. So you've probably seen legal dramas on TV or in movies and understand that in a legal case there are two sides, right? There's the complainant and there's the respondent, or in criminal law there's the prosecutor and there's the defense. And so in the human rights context we have a complainant and we have a respondent who gets the opportunity to make their case and try to explain the situation from their perspective and point of view. And what a respondent will often do is try to suggest, well, maybe there's no connection between what happened and a protected characteristic, or they may make an argument to try to justify the behavior and say, well, yes, we did take an action that caused a disadvantage to someone, and it was connected to a protected characteristic, but that decision that we made was justified for a variety of reasons. Do you want to maybe say a bit more?
When you're the respondent, you are, so in this case, like in my work, we're usually talking about work. So when I'm working with clients, it's usually employers. And so they will have maybe made a decision, for instance, to terminate someone's employment because they weren't performing well. So just use that as an example. So they said, Laura's been here, she's been working for me for a while, and she's really not, doing what I expect of her. Maybe she's coming into work late, or she's missing deadlines, and so I decided, you know what, Laura, this isn't working out, and I'm going to have to let you go. And Laura maybe told me before, or maybe didn't, that she has a disability. You know, maybe she has an addiction or a mental health or issue or some other invisible disability that was impacting her work performance. And so the question will become, was her disability related to my decision to terminate her? And those are, I would say, the hardest ones, where disability and performance are interrelated, and where employers may not know, they may not have been aware that there was a disability. Sometimes it's much more overt, and the disability is known, and there's sort of an intentional, like, I don't want sick people or disabled people working here, but that's the unusual case. So in that situation I gave, the harder one, we'd be talking about the connections. We know that Laura has a protected characteristic, she has a disability. I've treated her negatively, I've let her go, but where is that connection, right? And what was the reason for it? I would be saying, for instance, it was performance-based, and that was my legitimate reason, and then we would be looking at whether that flows from the disability. So you only really get into the 3 points over here if you are saying, well, I understand that there was a disability and I terminated anyways, or I terminated because of that. So carrying on my example, let's say I knew that Laura had a disability, but she wasn't, you know, she's a lawyer, she was working for me, and she was causing clients to lose their cases because she wasn't meeting deadlines. You know, that would be the kind of discussion where we would be talking about these things on the other side. So we would say, well, was it justified? Did I have a reasonable explanation? And is it a bona fide occupational requirement? So am I, as a law firm owner, entitled to say, well, as a requirement of the job, I need to have a lawyer who can meet deadlines. And if you have a disability that means you can't meet these deadlines, then perhaps that's a bona fide occupational requirement. That's a really unusual case where we're talking about that kind of analysis, because in virtually all circumstances, there's some kind of accommodation that can be made. So it's not like as simple as you can't meet deadlines, so you're fired, I have to fire you. It's generally more complicated than that, but that's what a bona fide occupational requirement is. You know, using some more, like, I always find physical disabilities easier to talk about when we're talking about accommodations. So, you know, one classic example that comes up is airline flight attendants. So they have to be able to reach the overhead bins. Perhaps there's safety issues about them being able to maneuver in small spaces and help people exit in the event of an emergency. And so there could be some kinds of physical disabilities that an airline might be able to say, well, it's a bona fide occupational requirement that you be able to reach the overhead bin or whatever it is, like get out the life jackets. And so that would be a position that the airline could take to say, well, we can only hire people who have these certain physical abilities because this is the nature of the work that we need them to do. So that's in essence what the respondent's case is. Usually, again, the focus is on, is there a legitimate other reason? So the negative treatment has taken place, there is a disability or some other protected ground, but is there a legitimate other reason? So that's normally, I would say, where most of human rights law cases are what we're talking about. And then we sort of get into the reasonable explanation and bona fide occupational requirement only in sort of a small subset of cases. You know, another example that I often give, I find this comes up a lot in pregnancy discrimination, where I don't know why, but that always seems to be, there always seems to be a reorganization while someone's pregnant that results in the pregnant lady being the only person who loses their job, right? Like that fact pattern seems to come up from time to time.
Yeah.
And the employers, the pregnant woman says, well, I have a protected characteristic, which is sex, I'm pregnant. I had a negative treatment or impact, I was fired. And so the question is the connection. So the pregnant lady is saying, well, I was fired at least in part because I was pregnant. And the employer is saying, no, we did a reorganization and your position was eliminated. And so it's the test between was there a legitimate reorganization, or was this pregnancy discrimination that's just being dressed up as something else.
Are there questions about this? About anything that
Yeah.
I've covered so far?
How long before taking maternity leave do you have to claim that you are pregnant?
I don't think you actually ever have to say that you're pregnant. And, you know, for most people at some point it's self-evident. But there's no rule, just like you don't have to tell people that you have a disability. You're not required to notify of that. In terms of taking a maternity leave, which is a kind of a different scenario, there may be requirements under employment standards. I know there's limits on when you can start a maternity leave, like to claim EI, like that you can't, you know, day one I'm pregnant while I'm starting my maternity leave today. There's some limits in terms of your relationship to your due date of when you can start. But in terms of notifying your employer, I'm not aware of any requirements at all on that front. You know, if your pregnancy was actually like somehow creating a hazard at work, I mean, I find it hard to imagine for pregnancy, but or created some kind of risk, you know, there might be a requirement to tell people. Like I'll give an unrelated example. It's like I have I don't know, like I've had some kind of illness or injury that means I need to take medication that is impairing me at work. Like it's heavy duty pain medication and it means that I'm going to be impaired. If that could impact your work or the safety, you have an obligation to disclose that, right? You can't just come to work and not tell anyone.
When you're saying you don't have to disclose you're disabled, well, that's easy if you've got a hidden disability. But I mean, it's kind of harder and it gets used against us more if we're physically disabled.
Absolutely, I don't think there's any doubt about
You're
that.
looking at the chair instead of the person in the chair.
Yeah.
You know, and that's why I say to people, can you look at the person, not the mobility device?
Yeah.
You know, because the person and the mobility device are two different things.
Yeah.
You know?
I think that's a great point, and it's very true. Yeah.
Because like, I mean, I can turn around and say, okay, you know, it's obvious I've got cerebral palsy. I mean, I'm sitting in the chair. I mean, I don't have to disclose I'm epileptic because I can hide that, you know, it's not obvious, you know, but like for something that's absolutely physical in someone's face, it's kind of hard to say you can't disclose it. This is right there.
Yeah, I think then also, like your point is really good about there are some things that are visible and some things that are invisible, and also, you know, because you're using a mobility device, not everyone knows what your disability is, right? And so you still have a choice about how much you want to disclose. And I think you were in our last session where we were talking about accommodations and how to talk about accommodations, and we're going to have some fun with that again this time. But I think sometimes, you know, strategically you might decide to disclose, and sometimes you might disclose less, and that's your choice, depending on what it is you are
Well, see,
looking
like
for,
the
right?
thing is like, for example, I've worked in, you know, the workforce, and I've also created, you know, the jobs that I have now. So, you know, there's a difference between being in the workplace and you know, being accommodated into something versus something that you've created yourself.
Yeah.
You know, because I mean, if I didn't create the employment that I have now, I wouldn't, you know, be in the workplace, because there's a lot. I've even faced it, and I know he's faced it, where, you know, they look at the disability instead of the person. And that's a big thing for them not hiring people too.
Your point makes me think about how much better all workplaces could be if there were more people with disabilities in the workplace getting to do things like create inclusive spaces and create job descriptions that work for other people with disabilities. It seems like something that is we're making slow progress towards, and I'm really glad that you've been able to create those opportunities for yourself. And I think the more people with disabilities that move into the workplace, the more voices there will be for change and for more inclusive workplaces where everyone's valued and included, and where workplaces can be designed with that more in mind. Something else that I've just been thinking about as we go through these elements of a discrimination case that you might be thinking about as well is just how difficult it can be to prove these things. And as Sarah mentioned, I just represent people who've made human rights complaints and who believe that they have experienced discrimination under the code. And I sure see a lot of people who truly believe they have a very strong sense and intuition because of their experience that what happened to them, their termination or having their hours cut, whatever it was connected to their protected characteristic. They really believe that it was because of their race that they didn't get a promotion, or it was because of their pregnancy that they lost their job. And they may, and this is what I tell them often, you may well be totally right. And how are we going to convince the tribunal of that? How are we going to, what evidence are we going to be able to give to the tribunal to help them see what you really believe and know in your heart? How are we going to help them understand that there was that connection between what happened and your protected characteristic? Because as Sarah points out, often a respondent is going to point to other factors that were going on, the restructuring of the company, the economic downturn that meant they had to do layoffs, problems with your performance that they say had been going on for a while. And what the tribunal says is that to prove discrimination, you have to prove it's more likely than not that there was a discriminatory explanation for what happened. More likely than not that your race, your pregnancy, your disability was at least part of the reason for what happened. We don't always, maybe even don't often, have concrete, in writing, really clear evidence that discrimination was at play. We don't always have the email or the text message or somebody who witnessed your boss saying that discriminatory thing, which can make proving a case pretty hard, but not impossible, because your story is your evidence, your testimony, you're telling your story to the Human Rights Tribunal is also really powerful evidence. It's nice when we have that really strong, documentary, concrete piece of evidence, but just because we don't have it doesn't mean there's no chance that your complaint will succeed. What the tribunal will do in those cases is listen to all of the stories and try to make their best assessment of what happened. And they'll draw reasonable inferences about what happened.
I feel like inferences come up all the time.
Yeah.
And so the most common place for inference is time, I would say.
Yeah.
So the sort of, you announced your pregnancy, the next day you were fired because of a restructuring, right? You know, when there's a proximity in time, or you've asked for an accommodation, or you've disclosed you have a disability, or you've needed to take a little bit of time off work to get some medical treatment. If anything negative is happening to you around the same time as those things happen, the tribunal will look at that, and that doesn't prove your case. Like, that alone is not going to be enough, but it does help when we're talking about which story is more likely to have been the right one. When you've got timing like that, it really helps to weigh in favor of the complainant in that case.
I do want to just talk briefly about this. This slide maybe feels a little bit out of order, but it comes up a lot as a question, so I thought we would just address it now. And that's the nonprofit exemption in the Human Rights Code. And people sometimes wonder about this because they've seen job ads where the posting maybe is just for a woman, or just for the job wants to hire a person with a disability or a person of a particular religion. And that is allowed in situations where the organization is a nonprofit And the nonprofit exists to serve a particular population or group of people. So maybe it's a transition house for women fleeing violence. That kind of an organization is allowed to just hire women, for example. Or maybe it's an organization serving Indigenous people, and they want to hire an executive director, and they want that person to be an Indigenous person too. That's allowed in those kinds of situations. So if we consider back to this slide here, without even having to go through the argument, the Human Rights Code just sort of acknowledges that that's reasonable in these kinds of circumstances. It's justified, it's reasonable that these kinds of organizations that exist to serve the interests and welfare of a particular group or class of people be allowed to prioritize hiring people from that same group or class of people. Does that make sense? Cool. There are a few other exceptions or kind of carve-outs in the Human Rights Code as well. For example, in the tenancy context, and people will have seen this before too, it's not considered age discrimination to have housing that's just for, sorry, this isn't in the tenancy context, this is in like stratas and purchasing apartments and stuff. It's fine, it's not age discrimination to have housing for people who are 55 and older. For example, seniors housing is allowed. Same with housing that's designated for people with disabilities. A person without a disability or with a different kind of disability couldn't come and say, oh, it's discrimination that this housing is not available for me.
So we're going to talk about discrimination and equality. So not every distinction is discrimination. And what that point is intended to make is that not every reason that people are treated differently is going to be discrimination under the Human Rights Code. Issues, for instance, that aren't covered under the Human Rights Code, I get a lot of questions about tattoos. Are my tattoo, like they don't want to hire me because I have a tattoo, or they've said I need to dress a certain way to cover my tattoos at work. Is that discrimination? And unless they're religious tattoos or there's some other link to a protected ground, they're generally not. And so employers are allowed to make that kind of distinction. So when you're distinguishing between people, that happens all the time, and it's not always obviously discrimination. Two people might apply for a job promotion, and the employer is going to choose one over the other. And that is discriminatory in the broad use of the term because they're discriminating in choosing. But when we're talking about human rights, there always has to be a link to the Human Rights Code to make the distinction discrimination. On the flip side of that, treating people the same can lead to discrimination. And I remember we had a good discussion last session about Tammy Mayoran, who was the forest firefighter, and that she was treated the same as everyone else. The same standard was applied to her. She had to meet the same fitness test. And so there's still, I think, a pretty common feeling that that's fair. Fair is fair, right? Everybody has the same test, and if you can't meet it, then that's just the way the cookie crumbles, right? But now at law, there's a recognition that treating two people the same can result in discrimination because of people's different personal attributes. So with the forest firefighter case, she was made to meet this fitness testing and was able to prove that the fitness testing discriminated against women because it was way harder for women to meet these fitness standards than for men. And so that was discrimination, even though it was the same. So what we have to do is take into account people's characteristics and actual needs. And whenever I'm thinking about human rights and talking to people about human rights, I say if there's a blanket rule, like if you're saying we always do this or we never do this or this is absolutely required of everyone, that's a point to take a pause because human rights is all about individual analysis and individual assessment and looking at every individual's unique abilities and attributes. And that's what you have to take into account when you're making decisions if human rights protected grounds are at issue. We look to the outcomes and the results. So there has to be a negative impact on someone for it to be discrimination. So I always have trouble thinking of an example of this, but hypothetically you could be discriminated against, i.e. treated differently, but if there wasn't any negative impact on you, like you have to prove in some way you were treated negatively. So I suppose maybe we flip it up and say you were treated better because you had a disability and you got more raise and more money. That would technically be discrimination because you're treated differently, but it wouldn't be something the Human Rights Code would look at because we're always looking at the outcome and there has to be some kind of negative impact. Intention to discriminate does not matter. I would say the vast majority of discrimination that occurs in at least the files that I'm seeing is unintentional. Employers are doing their best, making decisions that they think are best for their business, and those decisions are having an unintended impact on people who work for them. One example of that would be, okay, we're, my law firm is so busy now, Laura, that you're going to need to work on Sundays because we're going to open 7 days a week. So we have all these clients, phones ringing off the hook. It's awesome. This is great for my business, right? And great for you. I'll give you a raise. You can pay more, or I can pay you more. And then Laura says, that's great, but I'm a religious person and I have a Sabbath requirement, which means I can't work on Sundays. So my rule, which was everybody's going to work on Sundays now, which is great for me and my business, has unintentionally discriminated against Laura. I wasn't going into it thinking I was going to be discriminating against people, but I am. So that's just an example of unintentional discrimination. Laura, do you have anything to add on?
No, that was great. I was just thinking about the Sabbath kind of example because I think it really illustrates this slide really well. Sara has just implemented a policy at her work, and it's one of those policies that she flagged for us as maybe something to give us pause because it's a blanket policy that she's applying to everyone. Everybody is going to work on Sundays. And maybe she hasn't accounted for people's individual differences, like her employees, who has a religious requirement not to work on Sundays. So she's treated everyone the same. Everybody has to work on Sundays, but the outcome, the effect of that policy that applies to everyone is discriminatory because it has a disadvantaging effect on me as a person who has a religious requirement to not work on Sundays. And she didn't intend to discriminate, but the outcome, the result of implementing this policy is going to have a discriminatory impact. And so for her to be able to keep that policy, she's going to have to show that it's justified and that she couldn't accommodate me without it causing a big headache for her business.
So
and that's what we're going to talk a bit more about.
So I have two choices then, right? So Laura, we're playing this out, and I've told Laura my fantastic news about the growth of our business, and she lets me know, well, unfortunately, that's not going to work for me. So I've kind of a couple choices at that point. I can work with Laura to figure out something that's going to work for her, or I can double down on that and say, no, absolutely, we need that, because you know what? Our whole court system has changed, and now courts are only open on Sundays. And so that's the only day we can go to court.
Can you imagine?
Right? I love these wild examples,
Yes.
right? But that is literally the only day we can do the work that we do here, because all of our work is going to court, and we can only do that on Sundays. So, then we might be having a different discussion about a bona fide occupational requirement. The ridiculousness of that example, you can see how far you have to get to have those kinds of discussions, but that would be it. Yeah, and so the last quote here, I don't know what case that's from. This is Laura's slide, but accommodation of difference is the essence of true equality.
I think it's from Eton.
Oh, it's a great quote. And I've looked ahead to the next slide, which I think illustrates that beautifully. Oh, there are 2 slides down. It's talking about the difference between equality and equity. So you can see on the left, we are treating everyone equally. And everyone is given the same support and the same opportunity, but only 2 of the 3 are at the ballpark watching the game. And then so this is we treat everyone the same, which is fair and equal. When we look at equity, we see the boxes have been redistributed, and now everyone can see. And the people who needed a little extra support to get there have that, and the people who really didn't need any aren't taking that support that they don't need. I think I love that slide. I use this image myself in talks. Accommodation is a fundamental and integral part of the right to equal treatment. And people with different needs may need to be treated differently. And so this is again, I fast forwarded through Laura's slides. I was like, I just want to talk about picture. It's pictures are worth 1,000 words, right? So this is accommodation in the sense that people that have different needs are being treated differently so that they can have equal access and equal opportunity with everyone else that's around them. And so the duty to accommodate is how we shuffle these boxes at work. And we will change the terms and conditions of the workplace or the functions of the job. And terms and conditions of the workplace, to me, basically means everything related to work, right? Like it could be your schedule, it could be the physical place that you work, it could be the equipment that you use while you're working, it could be who you report to, it could be literally every aspect of your job is something I would call terms and conditions, or the functions of the job being what you actually do. And so when we're talking about accommodation, that's what we're talking about, is how can we make changes at work so that everyone experiences equality. And so if someone needs some extra equipment or support or some changes, their working terms and conditions might look a little different than someone else's, but that will effectively make them equal in terms of their ability to engage in the workforce. If we treat everyone the same, there will not be equality. And so if we're offering things to the general public and we're saying, let's say you can access our welfare application, but you have to do that. The only way to do that is to come in person to our office, which is not in an accessible building. So you have to climb a flight of stairs to get to the office. Well, we're giving everyone the same access, and we're offering this service to the general public. It's open to anybody to come, but that would require accommodation to make it accessible to everyone on the same footing. So that's basically, again, I have no idea what case that's from, but it is, I think I've summarized it.
You absolutely have.
Perhaps in a more basic, plain language way than the Supreme Court of Canada.
Always. The Supreme Court of Canada is not always known for its plain language and clarity. This case is a case called Eldridge, and it involved the services that a hospital provided, and the people who brought the case were deaf, and they didn't have any access to sign language interpreters at the hospital. And the hospital said, well, we're providing services, we provide them to everyone. We don't hang a door up on don't hang a sign up on the door of the hospital that says we don't serve deaf people, we're providing our services to everyone. But the complainants in this case said, yeah, but we can't actually access those services when we can't communicate with our doctors. And so what I really like about this quote is the reminder that sometimes service providers or employers have to do things. They have to take positive steps to make sure that people with disabilities or other disadvantaged groups actually get access to those services. It's not just enough to say, well, we're offering the service to everyone, just like the inaccessible building to make your welfare application. It's not enough to say that building's open to everyone if certain groups can't actually access it in a meaningful way.
So the duty to accommodate is, okay, the boxes in the picture that aren't there anymore, but everybody remembers. Whose job is it to move those boxes? And to me, that's what, when we talk about the duty to accommodate, it's like somebody has to move the boxes, right? And some employers would say, for instance, well, I'm not the one who needs the boxes moved, so it's not my job to move the boxes, and it's going to inconvenience me to have to move those boxes. So we should put that responsibility on the person, like the little guy who needs the boxes. He should have to move them because it's his problem. It's not our problem. And what the Human Rights Code has done is emphasize that accommodation, the duty to accommodate, is a shared responsibility, and that employers and landlords and in all the areas, I mean, my bias is always employment because that's all I do, but employers have a responsibility to accommodate. So they have a duty to do that. And that is because that's the only way we can effectively enable people to have access to the workforce, is if employers have that responsibility. So that's the duty to accommodate. Again, I'm going to kind of go off the paper slides here. Employers have a duty to accommodate employees with disabilities. And so, again, accommodating is that quote that Laura pointed out, which is you might have to take positive steps. So employers may have to do things. They may have to move the boxes so people can see. They may have to buy the boxes and bring them. There's things that they have to do to facilitate access to work. So it's not enough just to say, oh, well, this is just the way our building is, or this is just the way we've always done our work. They have to sometimes take active steps to change. How much do we have to do? I get that question all the time, especially with employees on sick leave. How long do I have to give them before I can replace them? Because it's really inconvenient to be running this without this key person who's I rely on all the time. And there is no answer to that. There is no timeline of how long someone can be off. The test is it undue hardship? So, going back to the example of the boxes and the employer having to buy the boxes. Okay, well, one question would be, how much do the boxes cost? If the boxes are $1 million each and my company only has $50,000 in revenue a year, well, then that's probably undue hardship because I'm going to be bankrupt if I have to buy the boxes, right? Undue hardship can be an inconvenience to other workers. So other workers also share in that responsibility to accommodate. So, one of the things I like about the box picture is one guy had a really good view, the tall guy before, right? He had a box and he was way up high, you probably could see everything. And he lost his box in the end, and he could still see, he still had access, but maybe it wasn't quite as good as it was before. So sometimes employers have to make changes that impact other employees in the workplace as well, and that can reach the point of undue hardship. An example might be like you have to fire one person to make this other person the accommodation work, or take some really extreme measures. That could be undue hardship, but sometimes it's required. But I would say, undue hardship is a really high standard. It's really hard for employees to prove that they've done everything they could do without undue hardship. And usually there are a lot of different things that need to have been explored before you could ever say, well, that's too much to ask of an employer. The goal of accommodation is to ensure that an employee who is able to work can do so. And so accommodation is all about having access to work for everyone who is able to do that. Accommodation doesn't go so far as paying someone when they can't actually do productive work. You know, there are limits to it, right? So if you, for instance, I had an employer the other day ask me if they had to keep paying someone who was off work for a long time. And it's like, well, if they aren't working, that you don't need to pay them. Like, you don't need to keep paying someone who's not working generally. Like, that would be if they can't work, they generally don't get, human rights wouldn't insist that you pay them. So the goal though is so that people who can work are able to work can work. And emphasis is on dignity of the disabled individual. So one of the key aspects of human rights is dignity. And the approach to accommodation in terms of discussions between the employer and the worker and anyone else always has to be focused on maintaining dignity and respect for the person who is working. Did you have anything else to add to that? Rambling on accommodation?
No, that was great, and we'll expand on those
Yeah,
things
question.
as we go
Love it.
along. Yeah.
So for the duty to accommodate, is it only unless it's brought to their attention that they have to have like a proactive kind of role in the duty to accommodate?
Yeah, that's a really good question. And this comes back to disclosure, right? To what we were talking about before. So if you need accommodation, you will have to disclose something to the employer. And how much you need to disclose depends on what you're asking for. So if you're asking for a small adjustment, you might not need to give very much information. If you're asking for something significant, then you might have to give more medical information to determine whether that accommodation is appropriate, right? What's challenging for employers is where employees don't disclose. And I'll go back to the example I gave with Laura, who was missing deadlines and showing up late, but never told me there was that she was having any kind of problems or had a disability. And so if she hasn't told me anything and I have no basis to suspect that, it's not my job then to accommodate that, because how could I do that if I don't know that it's there? One nuance to that is called the duty to inquire. Laura and I were just talking about that because we are planning for this conference that's coming up, and we're like, we need to know more about duty to inquire. So duty to inquire is, let's say Laura and I have known each other for years, which we have known each other for quite a long time now, actually, and she has always been very reliable, and then suddenly she changes and she starts missing deadlines and she's showing up late. My job as an employer might be to inquire about that, to say, hey, is anything going on that's impacting your ability to work? Because I noticed things have changed. And so the saying is like, you can't stick your head in the sand. So sometimes there's like really obvious signs that someone is having a disability or has a disability or some other problems. You can't just like pretend you didn't see it and ignore it. Like maybe I'm finding, drawers full of empty alcohol bottles in Laura's desk, right? And it's like, oh, I didn't know you might have an alcohol problem. I just, threw them in the recycling bin and fired you and carried on. But it had nothing to do with anything to do with a disability. So, there are sometimes signs. I mean, that's an extreme example, obviously, of an objective sign. But sometimes there are signs that you would have to ask. But in most cases, it's the employee's responsibility to provide the information needed so that the employer knows that they have a duty. They call it triggers the duty to accommodate.
If the employer asks the employee, is there anything that's affecting your work? And then they say no. And then you're like, okay, well, I'm sorry, you're fired.
Yeah.
Can that go back in to the employer because they did their duty to inquire?
It could. I wouldn't say, oh yeah, you're absolutely home free. Let's use the example with Laura. I'm just painting in this beautiful light today on Friday afternoon, right? So Laura's got her drawer full of empties that I'm finding as an employer, and I say, I've seen this huge change in her behavior, and she's not, meeting deadlines, she's showing up late, maybe she's wearing sunglasses at her desk, so there's lots of really obvious and objective cues that there's something going on here. and I say, hey, Laura, like anything going on? And she's like, nope, everything's fine. I say, okay, you're fired, right? Like maybe I didn't go far enough, right? But in most cases, if you ask and the employee says no, like employees still have a right to privacy, right? So I might choose, I'd rather not have the accommodation to be able to keep that information private, and that's your right too. But then you can't really say, well, the employer failed in their duty because they didn't even know that they had one. Does that make sense?
Mm-hmm.
It's, I think, maybe especially difficult in situations involving an addiction problem,
Yeah.
where denial can be a part of the disability, being in denial about the fact that you have a problem, and the stigma associated with admitting even to a great boss like Sara could still be really difficult for an employee to acknowledge that they have an addiction issue or a mental illness or other disability issues going on. So your example of like asking once and then saying, okay, well, you didn't say anything, so you're fired. Given those, aspects of the disability that we're talking about could.
But you could also get in trouble on the other way. So if I asked Laura that question and she said, no, I'm fine, and then maybe I leave it and I come back once again, and then like every day Laura's showing up at work and I'm like, are you okay? What's going on? And she's like, just leave me alone, right? I'm fine. And, it could actually cross the line where I'm at like harassing her. Right? I don't see that happen very often. What I tend to see is more either the information not being disclosed at all, or the employer sticking their head in their sand sometimes. Of course, never any that I work for.
Because you
or
give
myself
them some suggestions of best practices, and I bet you can add to this list. But what we like to see employers doing when they're starting down that inquiry path is to identify the behavior, identify what they've noticed, right? I couldn't help but notice that you're coming in late, and I've noticed on these dates you were quite late, and I see that you're wearing sunglasses sometimes at your desk, and I found some bottles in your garbage can. I also want to let you know and make sure that you're aware of this employee assistance program that we have, where if there is anything going on, you can access this support. So without sort of accusing somebody of having a particular issue, identifying what it is that you've observed that is giving rise to some concerns, making sure the employee knows that they'll be supported if there is something going on, and using that as the way to sort of open up the conversation in the hopes that the employee will feel comfortable to come forward.
Absolutely, and I think that they're like the sort of, it may sound not that nice, but I also think giving them the warning, right? So, in our example, saying, Laura, I've noticed all these things, I'm happy to support you if you're having if there's some issues, and we have employee assistance program, but if there's nothing going on and I can't help you with anything, unfortunately I'm going to have to think about letting you go because you're not meeting the job requirements. So that clearly has put Laura on notice that either she needs to tell me if she's having a problem, or these are the results that are going to happen. So that's another example. Duty to accommodate says employer must give serious consideration to how an employee can be accommodated, and it requires an individualized case-by-case assessment. So this is why I was saying it's always to do with that person. You can never sort of be like, well, we accommodate everyone this way. You can either take this or that. You're always going to have to do an individualized assessment, and that's often the issue that comes up, I find, in human rights cases, is the employer having to demonstrate that they looked at things on an individualized basis and didn't just apply a blanket rule to everyone. Reasonable accommodation is not the same thing as a perfect accommodation. So this has more to do with the complainant side. So as a person who's seeking an accommodation, it is a very good idea to have some ideas of how you might be accommodated, because you're the person who probably knows best for yourself what is going to work for you. And it can be sometimes very simple things. But sometimes the thing you identify might not work for the employer. Maybe the desk that would fit your needs the best is also the CEO's office, right? And you're like, this would be best for me because this desk has maybe that has the best access, or whatever it is about that particular desk, but it's the CEO's desk, right? And so you couldn't say, well, this is it, it's this corner office or nothing. This is the only way I can be accommodated, right? That would be you looking for maybe the perfect accommodation. If the employer says, okay, well, that's not really going to work, but we can take that desk and move it into the cubicle area where you would normally work. And that is probably a reasonable accommodation as opposed to the perfect accommodation, which might come with the corner office. So we do see that sometimes in employees getting very fixated on a certain thing, or sometimes, I do think there's a bit of sometimes trying to bake some other perks into an accommodation. So I'm always very cautious of, let's focus on what you actually need and how we can accommodate that, rather than like one particular solution, because that particular solution might have some other things around it that don't work terribly well. Accommodation relates to needs and not wants. Well, I think I just gave the best example of that, right? You might want the corner office with a big desk, but you might only need the desk, so how can we separate those things out? And it's a shared obligation. The employee must be involved. And so to me, this goes back to the disclosure question you had, and also like the example I always use, this probably came from a case, I think it did. Accommodation is a two-way street. I think maybe the Supreme Court of Canada said that, or someone did. I didn't make that up. But it's a two-way street. So each party has an obligation to discuss that and bring forward ideas and be flexible and be open and feed into that process in order for it to be successful. So it's never one-sided. It's not only the employee's job, and it's not only the employer's job. It has to be something that everyone's involved in. Sometimes there's a union as well, which is always interesting, in which case it becomes a three-way street, I guess. I don't know how that works. An T intersection, where the union might have to be involved as well, and might have to also provide solutions or information that would assist in that determination.
As Sarah said, employers have a duty to accommodate an employee with a disability to what's called the point of undue hardship. And that, sometimes I have different metaphors or ways of thinking about it, but I sometimes think of like a gauge that's like going up, and you're accommodating, and then you meet the point of undue hardship. And asking you as the employer to go any further than that point would be unreasonable. It wouldn't be fair to require the employer to incur an undue hardship to provide the accommodation. But where that line is different in every situation. It depends on a whole variety of factors. And so where the point of undue hardship is and how far an employer has to go to accommodate someone and accommodate their needs and rearrange those boxes is going to depend on the facts of the case, and is going to depend on what kind of accommodations are being sought, and also what the nature of the job is and the nature of the company, and what that company can reasonably do. So there are some factors, and they're on the second slide, that the tribunal says, the Human Rights Tribunal, when they're considering, has an employer accommodated this person to the point of undue hardship? These are the kinds of factors that are relevant to deciding where that line is. And probably the second bullet point should be the first bullet point, because it's almost always the first thing that an employer raises, and that's the cost. The cost of the accommodations. How much do those boxes cost? Are they $1 million, or are they $50? And how does that relate to the employer's ability to pay those costs. And that connects to the third bullet point, which is the size of the employer's operation, which you could think of as like physical size, but also just like monetary size, I guess. How profitable is the company? How much access to resources to be able to implement accommodations does the company have? Are they a $1 million company, or are they a pretty small mom and pop shop? The $1 million company, that's probably not even that much money. That's not the right number to pick. The $10 million company, the Amazon,
Right.
the Best Buy, is going to be able to do a lot more to bring about accommodations for employees that need them than the mom and pop corner store on your local street that maybe isn't turning a huge profit. So the size of the company and the cost of the accommodations being sought are pretty key considerations. And again, depending on the kinds of accommodations that a person needs, the physical size of the workplace and the number of other staff might be relevant as well. A person might need to relocate where in the office they are. Maybe the fluorescent lights in one part of the office cause them migraines, but if they could move to a different part of the office and be closer to a window, they would feel okay. Or maybe because of a disability that prevents or that affects their vision at nighttime, working the night shift isn't going to work for that person, but they could switch with somebody who works the day shift, and that would be the accommodation they need. And you can imagine that if it's a pretty big workforce and there's lots of people and lots of different shifts, that making that switch might be not that difficult. But if there's like 2 staff and that switch would mean that that person on the day shift can't look after their kids at night, then making that switch is going to be more difficult. And that also ties into what Sara mentioned about the impact of the accommodation on other staff. If they're going to be, put out and inconvenienced, maybe that is an undue hardship for the employer. Maybe not. Preventing them from looking after their kids might be an undue hardship, and so might be past that line on the gauge beyond which it's unreasonable to ask the employer to go.
So those are some of the hardest cases, I think, on undue hardship, the thorniest ones, are when you're balancing 2 people's human rights.
Yes.
So maybe accommodating one person's human rights is going to impact another person's human rights.
Mm-hmm.
I think that and safety are probably the 2 most, 2 things that will get you to undue hardship the fastest on that meter.
Yeah, I think that is probably true. And human rights so often is about balancing rights of different people that can sometimes be in tension. And those are definitely thorny cases. I haven't mentioned safety and risk yet, but that is a consideration for an employer when deciding how far they can go to accommodate an employee. It comes up in the context of addiction cases sometimes. Maybe if Sara didn't have a law firm but was running a construction company, and I as her employee, seemed to maybe be dealing with an addiction issue. The considerations about how far she might be willing to go to accommodate me might be different when the job I was doing involved me being 30 feet up in the air, working to
Swinging loads on a crane.
Yes,
over everybody
exactly.
else's heads.
Over everybody else's heads with heavy equipment that might fall off the crane, for example. So safety and risk, or the other example Sara gave earlier about the airline attendants needing to be able to take steps to ensure safety of passengers in the event of an emergency. Those kinds of safety considerations might come up in that context as well. So you can see that it's a really case-by-case assessment and depends on all of the circumstances, both circumstances affecting the person with the disability and what their needs are for accommodation, but also the circumstances of the employer and the nature of the job and their resources and ability to take those positive steps to accommodate the person's needs. That said, and I'm going to go back to the slide in the middle for a second and just touch on those last couple points, accommodation to the point of undue hardship, that's the language that we use in human rights law, that line of undue hardship implies that there might be some hardship involved with accommodating an employee. So coming up to that threshold, there might be some inconvenience, some things that are a bit of a challenge for the employer to do. And what the Human Rights Tribunal says is, yeah, sometimes there are going to be some disruptions, some inconvenience, but only if it's undue and unreasonable disruption and inconvenience can you say it's an undue hardship. Sometimes you might prefer, or it might be easier to not have to do these accommodations, but the Human Rights Code says that these are important and essential for you to do.
I think morale is where I see that. So that's the last point on your slide there, which is,
Morale at other
you know,
employees.
there is often resistance when someone is being accommodated and it's impacting others in the workplace. And, you know, this is something I hear often when I'm counseling employees, but their employers, like my other employees aren't going to be happy.
Right.
If I say Laura doesn't have to work Sundays, but everyone else does, they're not going to be happy about that.
They're going to say it's special treatment for
Yeah,
Laura,
and
right?
that's not fair,
Yeah.
right? Because it's not equal. We're not treating everyone the same. And so there's a real recognition that, you know, if your other employees are not happy about the situation, that's probably not undue hardship. That's probably hardship a little bit, but because the employer has to manage that, but other people not being happy with the accommodation is not generally going to be undue hardship.
And just before we shift gears a little bit, I just wanted to take us back to some of the slides that we skipped over when things shut down. The statistics that are talked about in those slides relate to the number of people with disabilities and some really interesting research that I came across last year, I believe, or maybe it was in 2017. In any event, it was research about the economic benefits to employers and workplaces of accommodating their employees. Excuse me. And I think it's really great to have that research to point to because, as I mentioned, generally the very first objection or concern about accommodating an employee with a disability is how much is it going to cost? Investing in some adaptive technology or a bigger desk or changing the work environment in some way, that's going to cost too much money. And what this research demonstrated was that for every dollar that an employer or company invests in providing accommodations for employees with disabilities, the benefit that they get back is much more than that $1. It actually makes good business sense, not even just from the perspective of avoiding human rights complaints, but actually improving morale in the workplace, preventing turnover, people having to leave the workplace because they're not being accommodated, and having to hire someone new and training them up on the job. Not to mention the incredible benefit to the company of getting the brains and skills and expertise of people with disabilities in their workplace. So I like having that research, and I think it is good to just point it out in a workshop like this, that providing accommodations doesn't have to be an undue hardship, and in general is going to benefit companies and businesses who do that.
Scenario number 2. Aaron applies for a job. He has excellent qualifications and he's very excited when the human resource director calls to offer him an interview. He uses a wheelchair. He asks the HR director to confirm that the office where the interview will take place is wheelchair accessible. She hesitates and says, "I'll have to get back to you." The next day, the human resources director calls Aaron and says they have filled the position. I like this example because I feel like this kind of thing happens all the time.
This scenario is based on an example that someone shared with us the last time we did these workshops for the Cerebral Palsy Association.
Maybe that's why I
BC.
feel like
Yeah.
this happens all the time.
Exactly.
I've heard this.
Yeah.
So-
It just happened to a friend of mine actually a couple of weeks ago, where she applied for the job, they told her it was hers, and then when she asked them if it was accessible, 2 days later they phoned her back and said, "Oh, somebody from the union took it." After 4 months of it being posted, nobody from the union took it?
Yeah.
Like, hello?
So I guess question number one in my mind about this scenario is this discrimination? Does anyone have any thoughts? Is that a hand up or
Yeah,
a?
well, like,
I love it,
if-
yeah.
Well, like, I was gonna say, like, if you want to prove it, if it's discrimination, you can check if it is wheelchair accessible, to like back up your case.
Right. So I like that you're already down the road of proof.
Yeah.
Which is awesome. So the comment was you could check whether it's wheelchair accessible. And I think that backing that up, we're talking about, well, if we said yes, this is discrimination, we are saying, yes, there's a disability, which is a protected ground. That's yes. Yes, there was negative treatment and that this person didn't get the job. Was there a cause? So this is getting back to usually where these cases are, is like, was there a connection between the disability and the refusal to give the job? And so for instance, if you were to do your research and find out that it is accessible, it is an accessible workplace, perhaps one option here is that it wasn't related. It just was a coincidence. That it was like, oh, she thought the job was still open when she talked to him, then she found out after it was already filled, and it had nothing to do with the fact that he had a disability. Anyone have any other thoughts on that in terms of what would come into play to decide whether there was a connection or not?
What other evidence or information might be helpful to know to try to figure out whether it was discrimination or not? What might you be curious about knowing? Another idea?
Did the person they separately hired also have a disability?
Who did they hire and what were their attributes?
Yeah.
For sure.
Yeah.
Oh, so yes.
Go ahead, you're on a roll, I love it.
Was it an online application or did they or did they see them in person and interview them?
Right.
That way they already had like previous knowledge.
Yeah. No, it's good. All good.
Yeah.
To me, this comes up with my favorite word, which is inference,
Mm-hmm.
right? So I think that's what makes this example interesting and common is it's the timing that suggests, because he had just given that information, so we're all inferring in the same way the Human Rights Tribunal might infer that it just based on this, it seems like that might have been one of the reasons why. I think another really important point, and I'm sure we've been through this, probably the part I missed, is that the discrimination only needs to be one factor in the decision making. So the fact that he disclosed that he had a disability and he didn't get the job, there might be an inference. I think really interesting also in this is like, what would you do? What would you do if you were Aaron? Anyone have, there's no wrong answers here. So one option I'll throw out would be move on, apply for another job. Probably don't shop at whatever that company is anymore. What else could you do if you wanted to do something?
Go to like your clinic or ask for advice from a lawyer and get what their opinion on the situation.
Love it. I never forget go talk to a lawyer as an option. That's a great option. I'll have to pay you later for that. Yeah, you could talk to, like, I know, for instance, lawyers like me, you have to pay to come talk to me about your issues, but there are human rights clinics. The law schools have legal clinics where you can talk to people for free about your case and see if it's something that might be viable. I also think like one option might be to call the company. I mean, it's a bit of a bold move, right? But you could ask the HR director and say, look, I told you I had a wheelchair and I feel like when you told me it was filled, that was part of the decision.
Or the fact that she told you she'd call you back, and then the first thing she says when she calls you back is it's been filled.
Yeah.
What are you supposed to think?
Right. So you could just ask. You could be kind of strategic and dig for some information and say, when was the position filled, right? All of there's lots of things you could do actually.
Yeah.
When you think about it. What else do you have in mind with this scenario?
Yeah, I think that would be a bold move and difficult for some folks to do. I think we all have a different comfort level in whether we would be willing to take that step, but you're certainly within your rights to ask the HR manager, oh wow, I'm really disappointed to hear that I don't even get an interview. Can you tell me more about how you filled the position, and do you have any feedback for me on my application, ways I could have made it stronger? And if you're feeling especially bold, like, couldn't help but notice that when I told you that I used a wheelchair or needed the space to be accessible, that it seemed to change your perspective on my application. And use that to get more information.
Or you could say, I'm just wondering, you haven't answered my question about whether your workplace is accessible. I just need to know that in case I'm applying for another job in the future.
Yeah, good one.
Right? We're very tricky. Well,
Yeah.
actually, come up with all sorts of ways to get information. And I think another option would be you could file a human rights complaint.
Yeah.
Like, I think based on this information, I'm not saying you would win, but it would be enough. You could go online and fill out the form and send it in, and that is something that you could do based, I think, on this fact situation.
I think so too, and we'll talk more about the process and the various steps involved in filing a human rights application and participating in the human rights complaint process in a later session, but something just to note for now is that when you go through the human rights complaint process, you're entitled to what's called disclosure from the other side. And you also have to make disclosure. You have to exchange all of the relevant information with the other side in your human rights complaint. You have to provide any documents or information that you have that is relevant to your complaint, and that the other side, the respondent, has to do the same. And so part of what might be relevant in this situation is information about who was hired instead of you as the applicant, and when, and maybe some information about their qualifications. Because in order for the tribunal to draw an inference about why you didn't get the job, it's going to be relevant to know how your qualifications measured up against the person who did get the job. And if the information shows that the person who got the job had lower qualifications than you did, less experience or less education or whatever the qualifications were for that particular job, that would strengthen the inference that your disability was at least part of the reason why you weren't offered the interview. If your qualifications were better than the person who ultimately got the job, then that suggests that there might have been something else going on.
You know what another great piece of evidence would be is if the job got reposted, right, or was still open, because it could be the job wasn't filled at all.
Yeah.
But you would find that out if you engaged in the human rights process. And so I think, the options are, whenever I sit down with clients, one option is always do nothing.
Yeah.
That is an option, and there's nothing wrong with that if that's a choice that you're making as an individual. You know, other options would be, you know, contact the HR and ask some questions. I think we talked about that. Do some espionage, see what we can find out, whether by asking questions or looking at other third parties. Talk to a lawyer or advisor, human rights specialist, or file a human rights complaint. Like, I think those are all very viable options, and it might be a combination of a couple of those that you might do.